Hello everyone, Kid here, back with another video. Today for you guys I'm going to be reading the Justice Martin vs. Mahoney court case. I'm going to leave a link to this document down in the description below for you guys along with our email. You can email us at themullings@gmail.com. I'll leave a link to that description. You can email us for private consultation. So for any other further ado, let's get right into it. Justice Martin vs. Mahoney. First National Bank of Montgomery plaintiff versus Jerome Daly, defendant. Judgment and decree. The above entitled action came on before the court and a jury of 12 on December 7th, 1968 at 10 a.m. Plaintiff appeared by its president Lawrence versus Morgan and was represented by its counsel R. Melby. Defendant appeared on his own behalf. A jury of talismen were called, impaneled, and sworn to try the issues in the case. Lawrence versus Morgan was the only witness called for the plaintiff, and defendant testified as the only witness in his own behalf. Plaintiff brought this as a common law action for the recovery of the possession of Lot 19 on Fairview Beach, Scott County, Minnesota. Plaintiff claimed title to the real property in question by foreclosure of a note and mortgage deed dated May 8, 1964, which plaintiff claimed was in default at the time foreclosure proceedings were started. Defendant appeared and answered that the plaintiff created the money and credit upon its own books by bookkeeping entry as the consideration for the note and mortgage of May 8, 1964, and alleged failure of the consideration for the mortgage deed, and alleged that the sheriff's sale passed no title to plaintiff. The issues tried to the jury were whether there was a lawful consideration and whether defendant had waived his rights to complain about the consideration, having paid on the note for almost 3 years. Mr. Morgan admitted that all of the money or credit which was used on as consideration was created upon their books, that this was standard banking practice exercised by their bank in combination with the Federal Reserve Bank of Minneapolis, another private bank. Further, that he knew of no United States statute or law that gave the plaintiff the authority to do this. Plaintiff further claimed that defendant, by using the ledger book, created credit, and by paying on the note and mortgage waived any right to complain about the consideration, and that the defendant was stopped from doing so. At 12:15 on December 7th, 1968, the jury returned a unanimous verdict for the defendant. Now therefore, by virtue of the authority vested in pursuant to the Declaration of Independence, the Northwest Ordinance of 1787, the Constitution of the United States, and the Constitution and the laws of the state of Minnesota, not inconsistent therewith, it is hereby ordered, adjudged, and decreed that the plaintiff is not entitled to recover the possession of Lot 19, Fairview Beach, Scott County, Minnesota, according to the plat thereof on file in the Register of Deeds office. That because of failure of a lawful consideration, the note and mortgage dated May 8, 1964 are null and void. That the sheriff's sale of the above described premises held on June 26, 1967 is null and void, of no effect. That the plaintiff has no right, title, or interest in said premises to lien thereon as is above described. That any provision in the Minnesota Constitution and any Minnesota statute binding the jurisdiction of this court is repugnant to the Constitution of the United States and to the Bill of Rights of the Minnesota Constitution and is null and void, and that this court has jurisdiction to render complete justice in this cause. That the defendant is awarded costs to the sum of $75 and execution is hereby issued therefor. A 10-day stay is granted. The following memorandum and any supplementary memorandum made and filled by this court in support of this judgment is hereby made a part thereof by reference. By the court, dated December 9th, 1968, Martin v. Mahoney. Justice of the Peace, Credit River Township, Scott County, Minnesota. Memorandum. The issues in this case were simple. There was no material dispute of the facts for the jury to resolve. The plaintiff admitted that it, in combination with the Federal Reserve Bank of Minneapolis, which are, for all practical purposes, because of their interlocking activity and practices, and both being banking institutions incorporated under the laws of the United States, are in the law to be treated as one and the same bank, did create the entire $14,000 in money or credit upon its own books by bookkeeping entry. That this was the consideration used to support the note dated May 8th, 1964, and the mortgage of the same date. The money and credit first came in existence when they created it. Mr. Morgan admitted that no United States law statute existed which gave him the right to do this. A lawful consideration must exist and tended to support the note. The jury found that there was no consideration, and I agree. Only God can create something out of nothing. Even if defendant could be charged with waiver or estoppel as a matter of law, this is no defense to the plaintiff. The law leaves wrongdoers where it finds them. See sections 50, 51, and 52 of Am Jurisdiction, Second Actions on page 584. No action will lie to recover on a claim based upon or in any matter depending on a fraudulent, illegal, or immoral transaction or contact to which the plaintiff was a party. Plaintiff's act of creating credit is not authorized by the Constitution and laws of the United States. It is unconstitutional and void, and it is not a lawful consideration in the eyes of the law to support anything or upon which any lawful right can be built. Nothing in the Constitution of the United States limits the jurisdiction of this court, which is one of original jurisdiction with the right of trial by jury guaranteed. This is a common law action. Minnesota cannot limit or impair the power of this court to render complete justice between the parties. Any provisions in this Constitution and laws of Minnesota which attempt to do so is repugnant to the Constitution of the United States and void. No question as to the jurisdiction of this court was raised by either party at the trial. Both parties were given complete liberty to submit any and all facts to the jury, at least in so far as they saw fit. No complaint was made by plaintiff that plaintiff did not receive a fair trial. From the admissions made by Mr. Morgan, the path of duty was direct and clear for the jury. Their verdict could not reasonably been otherwise. The justice was rendered completely without denial, promptly and without delay, freely and without purchase, conformable to the laws in this court of December 7, 1968. By the court, December 9th, 1968, Marcy versus Mahoney, Justice of the Peace, Credit River Township, Scott County, Minnesota. Note: it has never been doubted that a note given on a consideration which is prohibited by law is void. It has been determined, independent acts of Congress, that sailing under the license of an enemy is illegal. The emission of bills of credit upon the books of these private corporations for the purpose of private gain is not warranted by the Constitution of the United States and is unlawful. Forward. The above judgment was entered by the court on December 9, 1968. The issue there was simple. Nothing as the law gave the banks the right to create money on their own books. The bank filed a notice of appeal within 10 days. The appeal statutes must be strictly followed, otherwise the district court does not require jurisdiction upon appeal. To effect the appeal, the bank had to deposit $2 with the clerk within 10 days for payment to the justice of the peace. When he made his return to the district court, the bank deposited two $1 Federal Reserve notes. The justice refused the notes and refused to allow the appeal upon the grounds that the notes were unlawful and void for any purposes. The decision is addressed and the legality of the notes and the Federal Reserve System. The cases of Edwards versus Kinsale and Craig versus Missouri set out in the decision should be studied very carefully as they bear on the inviolability of contracts. On January 6, 1969, this court filed a notice of refusal to allow such appeal with the clerk at the district court, Hugo L. Hintage, for the county of Scott and the state of Minnesota, which is as follows. Notice of refusal to allow appeal. To Hugo L. Hintage, Clerk of District Court, Plaintiff, First National Bank of Montgomery, and Defendant Jerome Daly. You will please take notice that the undersigned Justice of the Peace, Martin V. Mahoney, hereby pursuant to law, refuses to allow the appeal in the above entitled action and refuses to make an entry of such allowance in the undersigned's docket. The undersigned also refuses to file in the office of the clerk of the district court in and for Scott County, Minnesota, a transcript of all the entries made in my docket, together with all processes and other papers relating to the action and filed with me as Justice of the Peace. The undersigned concludes and determines that MSA was not complied within 10 days after entry of judgment in my Justice of the Peace Court. Subdivision 4 thereof requires that $2 shall be paid within 10 days to the clerk of the district court for the use of the justice before whom the cause was tried. Two so-called $1 Federal Reserve notes issued by Federal Reserve Bank at San Francisco and Federal Reserve Bank of Minneapolis, serial number, was deposited with the clerk of the district court to be tendered to me. These Federal Reserve notes are not lawful money within the completion of the Constitution of the United States and are null and void. Further, the notes on their face are not redeemable in gold or silver coin, nor is there a fund set aside anywhere for the redemption of said notes. However, this is the determination of a question of law and fact by the undersigned, pursuant to the authority vested in me by the Constitution of the United States and the Constitution of the State of Minnesota. Plaintiff is there entitled to be accorded full due processes of law before the court in this persistent determination to not allow the appeal. If the plaintiff will file a brief on the law and the facts with this court within 10 days, or if plaintiff will file an application for a full and complete hearing before the court on the determination, a prompt hearing will be set, and if plaintiff can satisfy this court that said notes are lawful money issued in pursuance and under the authority of the Constitution of the United States of America, and the undersigned will stand ready and willing to reverse himself in this determination. Take notice and govern yourselves accordingly. I am bound by oath to support this Constitution of the United States and the laws passed pursuant thereof, and the Constitution and laws of Minnesota, not in conflict therewith. This is an important case to both parties and involves issues apparently not previously decided before. It is also important to the public. The clerk of the district court is an officer of the Judicial Branch of the State of Minnesota. His act is the act of the state. U.S. Constitution Article 1, Section 10 provides, no state shall make anything but gold and silver coin a tender in payment of debts. I'm going to end it off here, and I'll see you guys in the next video. Like, subscribe. Have a nice day. Bye.